Okay, guys, so I'm just going to do that real quick. Now, this video might actually be taken down because this video gives you a much stronger understanding and truth about what's going on behind the scenes with the Social Security Administration when it comes to potential bias against you as an individual when it comes to obtaining Social Security benefits, and heck, even including keeping your Social Security benefits when it comes to disability benefits, right? So your supplemental security income, disability insurance benefits, your disability adult child benefits, things like that. What I'd like to hear from you guys and what I'm curious about is whether or not you feel that the SSA is biased or has been biased against you in some way, manner, or form. The information I'm going to be giving you in this video is specifically going to be about the adjudication process, the ruling process, when they decide whether or not you are still disabled or if you are disabled for the first time, being found disabled for their SSI, SSDI, etc. programs. I need you to understand that at the end of the day, this information is very true, but it is also very harmful to the SSA. But here's the thing. When a government agency has harmful information come out about them, it can do one of two things. It can either try to punish those who go ahead and put the information out there. It's always an option. Or they can try to improve upon the system that they have and make it better for everybody. We've seen the government do it both ways many times. I think what's important to realize is that for us as a group of individuals, Americans, for us to be able to be successful utilizing this program that was put in place all the way going back to the original Social Security, law in the 1930s, 50s were SSDI, 70s were SSI. In order for us to truly be able to fix this, to utilize this program in a positive way, we have to address where the bias is. So we're going to do that in this video. We're going to be addressing where the bias is, what the problems are. Okay. So let's go through this real quick. And howdy to everybody that's in the live chat. I love when we do these live videos because I can see what people are texting. Let's start with the very beginning of the application process and where bias exists for those who are disabled. Number one, and a lot of people don't know this, when people go to get adjudicated at the initial filing level, like they just file for disability benefits, it doesn't go in front of a federal adjudicator. It goes in front of a state-based adjudicator. Now, this state-based adjudicator usually gets paid somewhere around 45 to 65 grand per year. Some of them have college degrees, some of them do not. The point is that when it comes to this system, ultimately, if you are found disabled at the state level, many of those individuals are able to tap into what's called Medicaid. And Medicaid for that state is one of the most costly line items that exists. So the states don't want more and more and more and more people to be found disabled because then they have to pay for Medicaid. And they don't want to have to pay for Medicaid. The whole reason we use the state to go ahead and basically adjudicate these claims is that the federal government uses it as a means to pay the states to go ahead and employ people. It's kind of like a carrot system where when the federal government wants the state to do something, they point and say, look at all those people we help you employ. Now, another thing to keep in mind is that as this process gets rolling and they start reviewing these claims and they start going through them, you do not have high-level federal judges going through all the documentation, figuring things out, etc. You don't have that. What you have are people that don't have a law degree, people that don't have extensive training compared to these administrative law judges. So you get some wonky decisions. Now, what is the main goal of the federal government hiring state-level people to actually figure out if you're disabled? It's to process as many claims as possible for as cheap as possible so that they can get through basically their backlog. The SSA will operate many, many times, and it's got about 1 million person backlog right now, at a large backlog that they've got to process as quickly as possible. Now, with that said, why don't we just get rid of DDS and have more judges? Well, you would have to pay significantly more money to have judges doing the same thing. So instead of using judges, people with law degrees, people with, background in this stuff, people who study this stuff all the time, they have DDS reps. They pay the state to hire people to process claims so that at the initial filing level and the reconsideration level, if your state has that, I think there's like 11 states that don't have the reconsideration level, but which is where you go initial filing just to the ALJ hearing. But most states are initial filing, reconsideration, ALJ hearing. What this all means is that the government pays the least amount possible to process the most amount of claims, which means there's a bunch of denials that shouldn't be at the initial filing level and the reconsideration level, that if a judge were to review it, they would find differently. But here's the trick. If you only have to pay a DDS rep, $45K, $50K, $55K, whatever, and you only have to pay an ALJ, they start out around 35,000. Most of them are, 55 to, honestly, a lot of them nowadays, because they've been in there a while, are 180,000 plus. So if we're talking like 65K versus 180,000, very quickly you can see if you had judges doing it, it would be triple the cost. So the point is, it's all a cost-saving measure. And the idea is that they can deny a lot of people, and that discouragement of them being denied is making them not appeal upward, making them go out and get another job. Statistically, we all know the truth, which is that if people are not found disabled, a lot of them, a percentage of them will go out and find some part-time job and just suffer, and they'll just suffer. Now, people are smarter about it now. They hire attorneys, they watch these videos, they learn about it. The whole process is they go onto the web, the internet, and they learn as much as they can about it. Next thing you need to know is this. As a part of the adjudication at the initial filing level and the reconsideration level, they'll send you usually to doctors, maybe one, maybe two, but it's usually a physical or mental, but sometimes it's specialty stuff, like a specialty doctor for your eyesight, a specialty doctor for some respiratory issue you're having, etc. Okay, but usually it's a general physical, general mental if you're claiming those types of impairments. The general physical is usually about 15 minutes. And the number one problem that I always have with these is that the doctors tend to be biased. When I say biased, instead of saying that the claimant is severe with their impairment, they'll say that they're moderate. They'll say that they're, basically not even moderate, in the mild category. And the problem with that is this. There's no way within 15 minutes to do a full physical examination on a claimant. There's just no way to do it. Mathematically, it's impossible unless the doctor is extremely fast with doing every little thing that they check off. You will notice, if you've ever gotten one of those documents where they do a review back from the SSA, specifically from DDS, you will notice that that document has all these tests that were completed, analysis, an outro with what they think the person can do in a vocational setting, all this stuff. Holy cow, how'd they do that in 15 minutes? And they don't. That's the reality. And the number one reason they get away with it is because claimants apply, have no idea. They go to that medical appointment, and then when their attorney after that medical appointment asks them what happened, and they go, well, they just did this, they did this. And the attorney goes, well, what about this test? And what about this test? What about this range of motion test? Oh, they didn't do any of that stuff. They didn't do any of that stuff. So the reason they get away with it is because claimants don't know. Okay. So the problem is that a lot of tests that are claimed to be done where they just mark off, yeah, they're okay. Yeah, range of motion is fine. Just a big line down all the range of motion. Everything's good. The problem is that they're claiming, and it's fraud, that they did these things when they don't actually do them. The mental side of it, where they do a mental CEME examination, is basically usually around 15 minutes to 30 minutes. And, those also come out less biased, but still biased. Okay. One thing I want you to keep in mind with this is that the problem with utilizing these CEME doctors, consultative examination medical experts, the problem with using them is that the whole baseline on this idea is about them collecting a snapshot in time. What is a snapshot in time? It is a moment in time where they see you medically and how you're doing. And when Commissioner Saul was in via President Trump, Commissioner Saul changed the evidence rules to give significantly more weight and potential weight to these CE doctors. Why? Because they knew at the SSA, under that Commissioner Saul leadership, that if they could get more weight or equivalent weight given to the evidence of that specialist against who you have on your side with your doctors, then their specialist would be able to balance it away from a finding of disability. And they knew this because it would greatly reduce the likely amount of approvals if they gave more weight to their doctors, which they did. As a result of this, there is a very strong bias that exists because of these CEMEs. Another thing to consider is the following. When many of these claimants go to basically be in front of one of these consultative examination medical experts, the medical expert usually has not read their entire record or half the record. They usually only have a couple of documents or none at all. Whose job is it to provide those documents to the medical expert? The DDS rep is supposed to forward your medical evidence, all of it, all that they've collected, to the medical expert. That's their job. They're supposed to do that. They're the ones who send it to the medical doctor. It's supposed to be their chain of evidence to the medical doctor. So what's the problem with it then? Well, the problem is usually by the time you go to that doctor, they haven't collected all the medical evidence. And many times the DDS reps will forget to go ahead and send the medical evidence over to the doctor. So the doctor is seeing you blind. So you're there, you're telling them your top 5 impairments, your symptoms, your signs, when they started, when they became severe, but they don't have a lot to go on. They don't have a history of medical documentation to use as a resource. That's not good. So that's a problem. Okay, another thing that you need to keep in mind as you go through this process is that there are these things called DDS managers, and who actually makes the decision for basically the claim to go forward, to go up to quality control for an approval or down to the local field office for a denial. Okay, let's go through this real quick. The way it works is that the DDS rep will write up a report, right? A DDE, Disability Determination Explanation Report. That report is then sent over to the manager. The manager then has to make a decision whether or not this claim looks good to send it for quality control to the feds, for the federal group to go ahead and rubber stamp it for approval and then send it back to the field office. Or the manager will say, I need you to go get more information, DDS rep, go figure out these things. Send them back, they go figure out those things, and they resubmit the report to essentially the DDS manager. Now remember, the main goal of the DDS rep is to process claims as quickly as possible, to get through as many of them, to get them off their desk, because if they're an aged claim, that is a statistic that looks bad on their record for continuing to work there. Now, nobody's going to fire these DDS reps because they've got a 25-year low employment right now at the SSA. They are losing DDS reps faster than any other group because they don't want to work there, because there's not enough money, it's too many claims, too much, push. They don't want to work there. And obviously, and let's just say the obvious thing, working with the disabled is not a good way of living. It's just not. When you have to interact with people that constantly scream at you, constantly crying, constantly telling you very sad stories, it is demoralizing. It is absolutely demoralizing. Most people that have worked for my firm quit at some point because of the demoralizing nature of interacting with the disabled. You can claim that it's not that way, but you'd be lying to yourself. So as a result of that, what we have here is a situation where the DDS manager somehow became a manager. And that's usually by efficiency, knowing the system, going through these claims very quickly. But there are certain areas where we know which DDS reps are likely to deny. They have statistics that they use, because it's a government job, to define what your workload capacity, completion, how efficient you were the decisions accurate. They have ways of going through that. Those ways tend to bias towards denying claimants. That's why you have such a significant denial rate at the initial filing level. while at the ALJ hearing level, you have a smaller denial rate. So something like 33% of individuals at the initial filing level basically get approval. Okay, that means you're looking at like 70% get denied. Okay, you're looking at a smaller percentage getting denied at the ALJ hearing level. So that tells you the math supports that DDS is denying too many people. So these managers that they have in place are being taught through their system and the metrics that they're trying to achieve to process claims more towards speed, get them through, get them done if you can, approve, but it is obviously you're seeing more denials than you should be because the gold standard are these ALJ hearings, right? Are the judges deciding the same types of percentages of claims that the DDS reps are? No, they're not. Well, if the judges are better trained, more educated, have more experience, then why are the DDS reps not trying to achieve what the ALJ judges are? Well, it's because they're denying a lot and they don't have those things, the experience, the knowledge, etc. When you have an administrative law judge read through a record, they can pull things out. They can pull tests out. They can understand what's going on. They know other types of impairments that normally come from it. They know the testimony that's going to come from the claimant. They know what happens with the jobs. Not the same for DDS reps. DDS reps don't have all of that. They have some of it, but not all of it. Okay. So another thing they have to keep in mind is that as you go through this process, sometimes when you're at DDS, they have an issue where they can't collect your medical documentation. For the most part, if you don't have an attorney, that's it. Doesn't matter. You're done. Which is why it's always insane not to have an attorney. But, people who are going to DIY it, they're going to DIY it anyways. They're going to do it yourself it. So the thing is this. You can then have the law firm go after the medical facility. But even if the law firm fails, because they just don't send it, they won't physically send it, DDS doesn't really have and use the same thing as what the judges have, which is the power to subpoena the records. Normally, they use what's called an 827. They send the 827 out, right? That's a HIPAA. The HIPAA says, give us the records. The people on the other end, the medical facility says, nope, I'm ignoring this. Nope, I don't want to. Nope, I'm not doing it. Okay. Then you have basically the judge's version of that. Judge will say, okay, attorney, go get it. Attorney tries. They won't do it. Attorney threatens the medical facility. They still won't do it. Judge says, okay, we'll send out an 827. They send an 827. Medical facility says, screw you, government. I don't care. Then the judge says, fine, I'll do a subpoena. Then it gets serious because then somebody from that facility might have to show up in court. So DDS doesn't really have and use that power in the same way. And as a result of that, there's also the potential bias there. There's also a potential bias in the medical field because the doctors and their ROI staff, think of it as their medical, evidence division, their paperwork division. They're not happy in the medical field because they used to be able to double dip much more easily. You'd have to pay a chunk for your visit, and then you have to pay a chunk for your medical documentation. Well, now that they came out with the high-tech rule where you can request it in digital form, they don't get to charge $1 per page. $1 per page was so incredibly profitable that basically there were mega companies like ScanStat and things like that were brought into existence as a result of it. I don't know what's up with this hair right here. I'm not even sure what's going on. There you go. So places like ScanStat basically came into existence. Mega, multi-million dollar industry of just basically going to the hospital, having access to their records, and then being the third-party group that just sends the records. That's it. That's all they do. They just receive HIPAA, receive high-tech, send letters. Okay? Send medical records, rather. Okay? Now, they do send letters, too, though. If they can send them, if they can't send them, how much it's going to be, etc. So the problem is that the medical industry is very unhappy about this changeover from the politicians to not make a cash cow business out of getting medical records anymore. So that's an issue. Let's talk about the ALJs. Are the ALJs biased at the OHO hearing level? Where the video we did directly before this explains a literal a literal, calculated, averaging bias that we know exists. And so what we know is that every judge, we know how many claims they did, we know how many they dismissed, how many they denied, how many they approved, how many decisions per day that they do, all that kind of stuff. We know all the statistics. They collect all the statistics on these judges. Okay. Bottom line is that some judges have extremely high denial rates. In the video before this, we literally went through the top 10 judges. One of them has a 10% denial rate. One of them went down to a 7% denial rate, which means that basically at 7%, 93% of the people that went in front of them were denied. And this was the bad list. The top 10 disability judges who are so biased against the system of finding people disabled that they're setting records on how many people they can deny. We know that there's a bias against the client, against the claimant, the person who files, because back in the day, approval ratings were much higher across the national board. They were above 50%. Now they're down to 44%. A couple of years ago, they were at 47%. Okay, that was just 2-3 years ago, 47%. So even in what I thought would be a very pro-claimant environment, with President Biden and Commissioner Kijikazi, it's now not so pro-claimant. We continue to see even more and even more judges denying claims. This isn't 100% the fault of Biden or Commissioner Kijikazi, and let me explain why. Many of the older judges that were taught in the old way of how to adjudicate the claim, which had a higher percent approval rating because the old way of doing it, how they were trained, the way that they would look at it, was very different. Okay. Those judges have largely retired. So the only ones that we have left now are those getting significant training that were on the system, 50, 60-year-olds, some very early 70-year-olds, and basically those who are younger, 40, 50-year-olds who are brand new, lots of training. The training shows this, and this. So the old ways of finding people disabled by the judges and the methodology used, they're dead. They're gone. The new ways don't find as many people disabled. And we know this because the government literally provides the data that tracks the bias amount that exists among the ALJ hearing level judges. Now, there's another thing to consider with these judges. Some of these judges are, putting it very simply, going to like certain types of impairments more than others. Classic example is fibromyalgia. A lot of female claims out there, a lot of female claims or claimants with fibromyalgia. Not nearly as many male claims with fibromyalgia. Judges do not respect certain types of impairments. The more the impairment is less capable of being seen or properly documented, or there's a machine that we hook you up to and it tells us a number, the less of that stuff, the more likely the judge is to frown on that type of impairment. And fibromyalgia is one of those. Okay. As a result of this situation, when you present a top 5 list, if some of your top 5s, especially the number 1 and 2, are those gray room impairments, expect there to be a bias against you. Okay. It's not the same as having a fusion that we can see on an X-ray and an MRI, and okay, there it is. Here's how it's changing. Here's one from 3 months ago. Here's one today. Got it. It's not like one of those. So there is more bias against it. Okay. There's also a preference on some judges when it comes to certain impairments. Some judges, whether they in their personal lives have experienced certain types of impairments or had a parent pass away from a certain type of impairment, or their child has a certain type. Remember, a lot of these judges have kids, and some of those kids, just to be very clear, are mentally disabled. So when a parent sees, a linear or a parallel impairment from something that they know in their family that they have, there's going to be a preference towards approving that type of impairment. It just is the way it is. Some of the judges are amazing at separating their life, the claimant, and their impairments. There's this one judge in Orlando who's absolutely incredible, like one of the most capable judges when it comes to neutrality Although she's the one thing she does, and I will say this, is that, she wants to get to her kids at the end of the day. So if you're like slow with your questions or not coming out and not being quick and not getting, if you're not starting on time, she's not happy. She gets there a certain time. She expects to leave at a certain time. Fine. But and I remember her explaining it to me one time, which is another thing, which I wish the SSA had a program where the disability judges could work with young potential future disability attorneys. I wish there was a program where they could integrate or something better, because then they'd be able to see how the stuff works a little bit better, and both parties could see it. The judges and the attorneys could, understand the other side a little bit better, instead of the way we have it now, which is that we learn about it from just constantly doing it over and over and over and over and over and over and over, so after so many years. All right, so the thing that happens is this. When it comes to basically judges, the best judges are able to say, this claimant, this personality, this charismatic or lacking of charisma individual is separate from what their impairments are. Are their impairments severe enough? Most judges are, in my opinion, not able to do that. If you get somebody in there who's very loud, very aggressive, very mean, challenges the judge, right? And some of you guys don't realize you do it. Like, I had a phone call, I think it was on Thursday, and I was sitting there bitter, right, when I got this phone call, because when I went to the homeless office, at some point, I saw like 3 or 4 people who weren't seeking disability benefits. And I always have to watch those people when I'm at that facility, because, they're more likely to steal something off of my desk as I'm running around meeting with other people, helping other people, etc., in other offices. And so one of them did. One of them that wasn't seeking disability benefits, because when people seek disability benefits and me to win their claim, they're not going to steal something off my desk, right? But one of these 3 individuals basically stole my mouse. And these Apple mouses, the wireless ones, they're not cheap. They stole it, came back, and I was fuming about it the next day. Then I get a call from this vet. Spent way too much time on the phone with him. I knew I wasn't going to take the claim. He kept challenging me. Well, this is the rule. And I always have to be very careful with vets, because vets, they have this authoritative tendency with their voice. And this is the females and the males. The vets, this is how it is. This is the rule, though. And I hear that, my brain's like, whoa, oh. And then usually about 5 to 10 minutes into it, my brain starts going, wait a minute, that doesn't sound right. Let me go look that up. And then I go look it up and find out they're 100% absolutely unconditionally wrong. And it's just the wrong. And so the bottom line was, this person kept challenging me, and I was trying to do other stuff, get stuff done, and I'm fuming about where the hell my mouse is, because I have to do accounting stuff. So the bottom line is, and let me give you an example. One of the things he said to me was like, so you won't take the claim? No, I'm not going to be able to take the claim. Oh, is it too complex for you? It's that challenging thing. Oh, is it too complex for you? Can't you handle it? Well, you can't handle it, I guess. And my response was, no, of course it's not too complex. I just don't have the time to work on this type of claim. This is not something within what I normally do, because I have so much of what I normally do. So they challenged me, right? And this happens with the veterans. They do that sometimes. Why can't you do it? Come on. What do you know? The other thing is, too, sometimes those individuals, when they've been on disability benefits for a while, nothing is ever their fault. I don't know what the deal is with that, but nothing is ever their fault. It's weird. Some of the veterans are amazing. Just the way they think, the way they get how America works. It's just way beyond what a citizen sees. Like, they just have a much better understanding. It's like the real school of life, actually, they got like a high level degree in. But I've noticed tendencies for those who are on disability benefits, that are vets, that have been on them for a very long time. Usually things are not their fault when they clearly are their fault. And it's one of these things where they're authoritative voice, because they've learned and then they've tailored it. They learn from higher up level individuals, like, this is how you speak and this is the way you direct it, stuff like that. And then my brain is like, oh, because my dad would always do that with me. My dad would have a very authoritative voice, and then my brain, after about 5 to 10 minutes of hearing that, starts to go, wait a minute, I don't think that's the rule. I have to go look this thing up. So the point is, I was sitting there fuming about my missing mouse. And what I did not do, which I'm making the argument that the judges don't always do this, and they don't, and very few of them do, and one of them in Orlando is very good at it. But what these judges and myself did not master in that equation is separating the individual, who they are, who their charisma is, how they're attacking you as a person, how they're baiting you with these questions and they're baiting you with these statements, how that person needs to be separate from the legal issue that's in front of them. That's tough. When somebody is insulting to you, when somebody is mean to you, when somebody is rude to you, and you still have to sit back and say, okay, their claim is this. Are they severe enough? That's very difficult. And now some of you are probably sitting there thinking, well, is it really that difficult, though, to like separate that? Let me explain something. For those of you who have been found disabled, you are living a very cleansed mental state, a very cleansed mental state, because you don't have to process claim after claim after claim after claim after claim after claim after claim. Judge is unhappy. This one wants this done. It has to be in 20 minutes. Your hearing is around the corner, and I mean in 5 minutes. You live a very, very cleansed mental state. Sure, you could have mental impairments. You could. Sure, you could have physical impairments that cause pain, but you do not have constant hammering every single day of getting things done. So you live in a better cleansed state, right? You can process things and not feel completely overburdened unless that is your impairment. Okay. So as a result of this, it's very tough for these judges who are getting hammered with hearing after hearing after hearing after hearing, and their writer is reaching out to them via email about some issue they found in the file that would change the decision, but the judge really didn't like the claimant, so what are we going to do? Do we change this? Do we modify it? The writers are there to write the brief in the form and manner that the judge wants. Okay. So the bottom line is there's a difficult issue of how do we separate who the claimant is as a person with what their actual impairments are. So when somebody states to me, I'm going to go in there and piss off the judge, my automatic idea is that person is very likely to get denied, because the judge, very simply put, has to deal with a lot of claims. And the judge is looking at a percentage of approval. Now, it's just kind of like police. If police do too much of one thing, they're going to get reviewed. Just like with administrative law judges. If the disability judges approve too many claims, they're going to get reviewed and go back for training. They have like a whole little rinse repeat training thing that they do for them. So when they meet so many claimants in a day, and they're like iffy about which one they want to approve, which one they don't want to approve, and one of them of those two is just mean to the judge, which way do you think it's going to go? You know the answer. I know the answer. I live it. I live that answer. So my goal is to make the claimant have what I consider to be a smooth hearing. A smooth hearing is where we give the judge everything that the judge needs to make a decision. We obviously try to have the claimant explain in detail what the impairments are, how they limit them, when they start, when they became severe, what are the symptoms, what are the signs, what are the medications, what are the side effects, what are the job functions that they couldn't be able to do, what are the at-home functions they wouldn't be able to do, what are the issues when it comes to mental interaction with the general public, family, friends, coworkers, whatever, right? There's a lot of categories. We try to give the judge what they need to approve it. But when the claimant rolls in there and is screaming at the judge, which way do you think the judge is going to want to go with that claim? Some of you guys think you're so tough that you're going to make the judge afraid of you. The judge presses a button and somebody comes in the room. The judge is protected by the federal government on their decisions. How afraid do you really think they are of you? Many of those judges are making between $135 and $185K per year. They've got money. Okay? Usually a family life. They have the protection of the federal government and guards. So you tell me, how afraid do you think they're going to be of you? Not much. All right. There's another thing that is potential bias. Some judges hate when they receive remands. It's very clear when you begin the hearing because the judge gets frustrated. They're frustrated that the claim is back on their docket. It's like something they got rid of, but then it just magically climbed back up onto their desk. Some judges don't mind the remands. They get it. They got to process so many claims so quickly. They can only do so much, they can only do so deep of a review. So when like that article came out from the federal court system at the higher docket, where like district, circuit, Supreme Court, when they came out and said they were frustrated with the ALJ hearing decisions, the reality of the SSA is the SSA cannot have deeper reviews because they don't have enough personnel, time, and money to do it. That's just it. You get a claim all the way up to district, circuit, Supreme Court. Supreme Court can take a lot of time to decide something. They can take a lot of time to think about something. They can write really deep decisions. They can go back and quote maritime law from Great Britain. Disability law, you can't do that. You got to process these claims 2 a day, 2 a day, 2 a day, 2 a day decided by the ALJs. Okay. So it's a speed thing to get as many processes as possible to cut down on the backlog. All right. Now, there's another thing too. AAJs at Appeals Council. That's the next level up. So initial filing, reconsideration, ALJ hearing level, and then Appeals Council with the AAJs, which are the administrative appeal judges. The administrative appeal judges try to catch things that are done incorrectly by the judge, whether it's fact or law. These potentially could be the least biased individuals because they're just reading records. They're not physically in front of the claimant. The claimant can't piss them off in person. So as a result of that, what you have to keep in mind is that you would think these would be the least likely to be biased. And remember, a lot of these AAJs, there's a percentage of them that are ALJs that had some medical thing happen where they just couldn't do physical hearings anymore. So the AAJs, they just review claims, right? They don't have to physically do these hearings. Well, you would think that they would be the least likely to be biased, but the unfortunate thing is that the higher you get to the sun, which is the commissioner, the more the commissioner is aware of the potential issues that take money, take time away from the SSA's ability to use the rest of their budget. So Commissioner Saul came out with a rule change for weight of evidence and basically killed off the number one reason that claims could be appealed, which was the weight of the evidence standard, to Appeals Council, being that your medical professional that you've seen 15 times over a 4-year period should have more value than this administrative, than this person, this consultative examination medical expert that you might have seen for 15 to 30 minutes. And the reasoning that they used for that was that medicine is magically different now. People don't have one doctor for their entire life. They have a specialist here, they have a specialist here, they have a specialist there, they have their GP. So why shouldn't their 15-minute, 30-minute doctor, their psychologist, their psychiatrist, their rheumatologist, their whatever, why wouldn't their doctor, ophthalmologist, why wouldn't their doctor be worth as much as one of yours? And so the problem is they changed the legal standard where us as attorneys, we couldn't just appeal up to Appeals Council based on weight of evidence. The judge didn't consider and give enough weight to my client's doctor. And they changed that rule so that we couldn't throw as many claims up to Appeals Council. The reason why is Appeals Council had too many claims coming up to them from their opinion. And it was one of those situations where they wanted to cut down on cost. The SSA every single year does not have enough money to actually process what they're doing, especially with this horrific inflation that we're dealing with. So what happened? Well, what happened was the commissioner said, okay, we're going to kill off their ability to do the major appeals that they normally do. So is there bias at the Appeals Council level? You bet. Is there bias above the Appeals Council level? You bet. It was the commissioner's office by Commissioner Saul that did these things, that put these things in place, that pushed these things forward. So unfortunately, at every single level, and I mean, we could do it on the local field office too and explain the potential bias there, but at every single level, there is bias at the SSA. Every single level. So at the end of the day, you might ask yourself, what are we doing to fix these things? How is President Biden approaching changes to the Social Security Administration by and through Commissioner Kijakazi to make sure that the claims are more appropriately handled? Well, first off, you need more money. He requested more money from Congress. They didn't approve it. Second of all, you need more people. They've been trying to hire people left and right, but it's hard to get people to do a government job that doesn't have a lot of accommodations. Third thing, there is a culture at the SSA at this point. When you work with claimants for a very long period of time, which is, we're talking about managers, executives within that agency, you develop, no matter what you do, biases. Okay. I can hear on a call when somebody calls in likely what their impairments are before they even tell me, based upon what's going on with their voice. It's that same ability to read something that also causes our brains to conclude things. Sometimes those conclusions are not correct. Sometimes the information, the thing is not there. But the problem with the disability industry is that people are 100% usually relying on that money to be able to survive on planet Earth. Also, there is a significant portion of those who become disabled who don't have much education. And therefore, the less education you have, the less experience with work that you have, the less customer service ability you have. So when it comes to a lot of SSI people, they tend to be very aggressive and mean towards the SSA reps. They swear at them, they tell them off. How could you do this? How could you screw this up? This is my livelihood, yada, yada, yada. So those DDS reps, those SSA field office reps that are getting yelled at a lot by these SSI claimants, at some point they learn to hate the disabled. At some point they learn to not want to have to put up with somebody's problem. And this causes an overall arching bias. And I've had employees where I've had to literally sit down with them at the firm and say, hey, look, and this isn't Karen from the mail. Everybody, well, I guess you guys don't know, but everybody at the office knows we do not allow Karen to interact with the general public. We do not allow her to interact with the clients. All she does is mail. She's a very, this goes here, and this goes here, and this goes here. And this is how it works. Great person for the mailroom. Amazing person for the mailroom. Not so great person when it comes to interacting with the clients. She's also the type of person who has very little, how do I put this, compassion for people who want to complain and whine for something that the claimant screwed up themselves. Like the claimant will be like a classic thing that a claimant will do. I did this and this happened to me. Can I sue? Well, what can I do to fix this? Well, how long ago did it happen? It happened 20 years ago. Well, statute of limitations, A, and B, why didn't you work on it back then? Well, it's not my fault. I don't know anything. Well, you're asking the question now. Why didn't you ask it back then? It's one of those things where the claimant's like, you can't blame me for anything. There's nothing I could be blamed for. Right? We don't allow Karen to work with the clients. She's just not, there's no compassion. But that's the point, is that in this industry, some people have an obnoxious amount. They produce compassion, right? You guys hear me on these telephone calls where people call in and you're like, how the hell do you put up with their shit? It's because I've somehow found in my own self-hating to produce enough compassion to understand where they're coming from. That's what it is. But other people don't have that. Other people slowly getting yelled at, getting told that they have to do this procedure, and that claimant's mean to them, and now they have to do something nice for that claimant that was just super mean to them. It erodes them. It erodes them, and it erodes their respect for themselves. And then all of a sudden, they don't have much respect for themselves. So why would they have respect for that person who's just been mean to them? And that creates a bias against people who sound like that person, who have that person's impairments, etc. And it's real. And you can train some of that out of people. You can pull people aside and say, hey, look, I need you to treat everybody super nice and be super friendly and be super courteous and be super awesome. You can do that. But it's a lie. Because when people are treated continuously, repetitively wrong, when they're being treated poorly, and it just slowly erodes their capacity to be nice to other people, that's why you get some of these government employees where they come out and they just like, don't care, not my problem. And Pence got caught doing that. Remember when they were like, why do you support Ukraine so much, but yet your cities are burning? Pence was like, not my problem. Not my problem. Ain't my problem, bro. That's basically what happened. That's, if you're wondering where that bias is and how that occurs, that's what that was. Somewhere in there, Americans did Pence wrong. Somewhere in there, Pence is not happy because of what Americans did to him. Their cities are burning. And he said, not my problem. Okay. I hope this video was helpful to explain to you the details of bias that exist. I will catch you guys a little bit later. I have to go and do some outside work now, but you have a wonderful, wonderful night. Let me go to the comments real quick. Christian, Mama said, question, Walter, can the SSA change the judge's approval decision? I was told since I did not have to testify at the hearing that it was an automatic approval and it was set in stone. No. If you don't have to give testimony. Okay, here's when it's set in stone. When the judge tells you that they're going to approve the claim during the hearing, and then you get the approval letter, that's set in stone. But even that set in stone decision can be overturned by appeals counsel within so many months. So long as you get past that so many months where appeals counsel could grab the claim, then you're good. But there's always appeals counsel standing over the claims where they could grab the claim and say, nope, you missed this, you screwed this up. No. So if you were told that you didn't have to testify, that could be for a lot of reasons. Usually it's a good thing for the claimant. Usually it means that the claim is really solid and it's going to be an OTR, an on the record decision, where they just look at your record, look at your decision, look at all the stuff that's in your record and make a decision. That's usually a good sign. But I think this is important for you to realize, the bottom line here is that it's not certain until the time period appeals counsel has to go ahead and review the decision of the judge, the ALJ. Until that runs, you're not safe. Okay. Let me see if there's a few more questions. Let's see. Okay. Richard Carr said, I'm not disagreeing. I'm just honor shaming. That's an interesting. How would you define honor shaming? That's an interesting phrasing. Okay, so let's see. Slathering said, let's just say I made the case. Oh, that's not a question. Let me go down here, see if there's any more questions. Okay, so Orion said, how long does it take to straighten out the payee? Well, I mean, look, once you're found disabled, usually if you're prepared, and you can even pre-sign a sheet that says this is the payee I want. If you go ahead and submit that, then they'll have your payee set up for you to get your check, within 3 to 4 weeks after you get found disabled. But if you don't, and you have to find one, or you have to use one of those companies, it can take a couple months to go ahead and solidify everything. But usually it's less. Usually it's 2 weeks. Okay. Next question. If they say you need one, but the local rep requests you be your own. So if you need a payee, you can't be your own payee in the sense of being a payee. You're either receiving your own benefits or you have a payee. So if you're required to have a payee because of a mental impairment, then you have to find somebody else to do it, whether it's a person or a company. Okay. But you can't be your own payee because then you wouldn't have a payee. You would just be the one receiving your benefits. Let's see. Thank you, Christian Mama. Very cool. Let's see. Yeah. So look, Orion, if the local DDS rep or if the local field office rep thinks that you could actually handle receiving and keeping and accounting for your benefits, then do that. That's the easiest option. Just don't screw it up. Don't get arrested with drugs on you. Don't get arrested while you're drunk. Don't get arrested for things like that, because that's going to make you not be able to be your own payee very quickly. Okay, Richard Carr said, joking with you. Very cool. So slathering's the problem with local companies, and there's 3 of them. There used to be 4, but then one of them, that 4th one, was smaller and committed a bunch of fraud. But there's 3 big ones. The problem with those companies is that it's basically just we have the money, we send you the money, you use the money. It's not like if somebody has a problem, which is usually why a payee is required, some mental impairment, a drug problem, a smoking problem, an alcohol problem, whatever. If somebody has a problem, then the bottom line is, to be fair, the companies are not usually the best option. The companies are like an option in case there's nobody else in that person's life who's willing to put up with that person's shit. That's basically what it comes down to. If somebody doesn't have anyone else in their life who's willing to put up with their shit, their abusive behavior, abusive screaming, their constant bullying, their claims that the payee is frauding them by not giving them all the money, even though they received all the money, they'll claim, oh, that person didn't give me all the money. Open a federal claim, get me $500 more. People are realizing that being somebody else's payee, like if it's family, yeah, they'll probably help it out. They'll do it. But when it's not, it's usually not a smart idea to be somebody's payee, because, the moment that person claims that you didn't give them all their money, even if you did, now we're talking federal, federal claim being opened against you, and whether or not the money was paid out, and you got to prove it. You got to find the bank records, and I gave him the cash. Well, how do we know you gave him the cash? Okay. Okay. JT said, so let's see. The real Robert McDonald Jr. How are you going to get a fair shake with so much bias in the system? You got to hire an attorney, and you got to basically figure out what the statute is. And you have to be Mario running down the road, jumping up and hitting your head on those coins and getting those coins, those little opportunities every time one of them pops up. That's the reality. The reality is you have to basically, every time there's an opportunity, take advantage of it. That's it. Everything that you could file, everything that you could claim to increase the worth of evidence, reduce the weight of evidence, etc., you have to be on top of that. That's the reality. JT, how does the approval or CDR process work for recipients living overseas? Oh man, that's a huge, huge question. That's email me that, and I'll do that in another video. Slatherings, how much do they keep? I'm not sure what the current rate is for the companies. I'm not sure, but they do get paid. They get paid to basically distribute funds. So it's not enough for most people to do it as like a company thing. You have to have lots and lots and lots of claimants, and then just have it set up as part of a bank system where it distributes to an account for that person. But to be honest with you guys, the payee thing, they're probably going to change that in the future to just be a different system, because there's a lot of people getting funds that, are then spending it on drugs, and then all of a sudden they just stay off the radar. And they know how it works. Like they'll go to the doctor, and the illegal drugs won't be in their system after so many days. So they'll go after that many days to the doctor. So yeah. Let's see. Vaughn said, I can't, I'm not going to say that judge's name, because I go in front of that judge all the time. Literally last week, I was in front of that judge. So I'm not going to say that judge's name. Let's see. Anyways, I will catch you guys. Okay. So final question. Walter, how much weight does a functional capacity exam have? Also, why would your doctor need to have SSA order one? Okay. So RFC documents, which is like residual functional capacity form, and they fill out what your capacity to do the ings are: walking, standing, pushing, pulling, crouching, kneeling, stooping, whatever, remembering, focusing, completing what you start, finishing what you start, blah, 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 whatever. Those forms are extremely important and get a ton of weight, because it outlines exactly what they think you could do. And then they compare it against a vocational chart to see if you could do jobs in the DOT. So they're worth a ton. You want to get your doctor to fill out a physician statement or a residual functional capacity form, because it is a counterbalance to their doctor being hired to literally do the same thing. And it's a knockout rule. You're trying to show that you have severity. They're showing, and they'll claim it's neutral. I clearly disagree that they'll claim that they're neutral, but it's obviously something where it shows not as much severity. And I'm sorry about my hair. I'm not even sure what's up with this, but it's just, it's doing its thing today. So yeah, there we go. The doggies are right here. So you gotta understand, the doggies are not with me because I'm on like, what is this called? It's a bar. It's like one of those wooden bars. So for example, do I have any paperwork here that I can't let you see? No, I don't have any paperwork here that I can't let you see. So I'll show you real quick. I'm at this super high bar, but over here, if I'm going to move you guys real quick, you can see right over there, that's where the doggies are. They just chill out, hang out while I basically do these hearings. So that's Sweetie. Let me see if I can get my finger in there. That's Sweetie. She's a Piggle Puff, 80-pound bully. And that's Shadow. Let me get right there. Sorry, right there on the green screen. He's doing great. He is a pocket pit, although he's a combination of a zillion things. So let me put that right there. Anyways, guys, they're always with me when I do these. So they're doing great. They're chubby. They had steak last night. I go to Walmart and I buy the chuck steaks. And I have one of those little Ninja grills, and it takes me about 10 minutes to basically throw it on, cook it, and 10, 15 minutes. And then basically you flip it over once, you pull it off, and you cut it up, and they love it. They absolutely love it. So I mix that in with their kibble. They hate kibble because they're so spoiled. I don't blame them. I don't like eating cereal all the time either, but I do. Because, all right, look, there are some cereals for human beings. Let's just be honest about this, where they're just obnoxiously sugary and they taste so good. So when you get the Fruity Pebbles cereal with the marshmallows in it, it's hard to not enjoy a bowl of that. It's very difficult not to enjoy a bowl of that. Anyways, I will catch you guys later. You have a wonderful, wonderful day, and we will go from there. And in the not too distant future, you're going to be seeing me pop up on other hosted platforms like Facebook and Twitter and things like that. And you will be seeing shorts, 60 seconds or less videos in the not too distant future. I'll catch you guys a little bit later. Have a wonderful, wonderful day, and we'll go from there. Thanks so much, guys. Bye-bye. Bye-bye. Oh, and remember,